Okay.
So, hello everybody. Good evening when you are here in Europe, or good morning when you are where my guest today is. Pingu is located in Palo Alto in California. And first of all, please enjoy our discussion. It would be even better if you write some comments or questions, and when it is possible, anyhow, I will integrate it in our discussion. So today, my guest is quite prominent in the world of litigation, of IP, especially patent enforcement. She's active in China, and so the first of all question is, dear Pingu, thank you very much for being here. And so explain us who you are, what you're doing, and why you are in Palo Alto when we talk about China.
Good morning, good evening, everyone. My name is Ping. I've been practicing IP law for close to 20 years. I was born and raised in China. I have a computer science background. I practiced in New York at Morgan Finnegan, and then at Milbank Tweed for 8 years before going back to China. I am a licensed U.S. patent attorney. So I went back to China in 2009 and started working for my multinational high-tech company clients. The reason why I am in Palo Alto is because my daughter and my husband, my family members are all here. So I came back at the beginning of last year, 2020, for Chinese New Year, because we had a break in China. Then I have been, stuck in here ever since. But I'm pretty happy to have time with my daughter, and she is 13. So I'm enjoying my time here. I really appreciate Alice giving me the opportunity to reach out to more IP friends. And
Okay.
Yeah.
Yeah, wonderful. So I have a 13-year-old boy, so they really need you. I know what you mean.
Yeah.
Okay, let's go back to IP. So what we heard recently is that China becomes more and more attractive for patent trolls. I mean, for some of our audience, maybe this is totally new. So we learned that patent trolls are a U.S. American phenomenon, and now we learn more and more that it comes from that happens also in China. Can you explain us a little bit what's going on there and why it is so attractive for trolls to be active in China?
Yeah. So let me give you the number first. I have handled, or currently I am handling 14 cases representing practicing entities to defend case filed by troll. So currently I have 10 pending cases. That's patent infringement. And then at last year, and then 2019, we had four cases where we managed to force we got one infringement, and then on the rest of the three, we forced the patent non-practicing entity to withdraw the claim before trial start. And then we also managed to knock out one of the patent entirely, which had survived two previous IPR, two patent validation before. So that's pretty, a sliding success for our client. So the client is pretty happy, but there are more cases. The trolls are getting more active. The reason why is because, so I practiced in New York before. So in the US, they still have, after there's infringement decision, they have to go through eBay factors, right? But in China, there's no such thing. it's almost automatic. So when you have injunction, when you have infringement, you always have automatic injunction. This gives practicing entity a lot of pressure.
That's a powerful weapon, isn't it?
Very powerful, and because they are, they're manufactured in China, they export from China to, overseas to Europe, to the U.S. and many other countries. If they can get, infringement decision, they can essentially force them to stop manufacturing, which is really very, very powerful. And also,
is there any tendency that you will have a change in the, because you had already a change in the patent law? So are there any tendencies to, let's have any evaluation, validation, anything which reduces a little bit that automatic mechanism?
Yeah, there has been a lot of cries from industry to curb the misuse of litigation in China by the patent non-practicing entity. And then we have not seen the legislation nor the Supreme Court judicial interpretation yet. But in one of the cases that we are handling, we're actually, two of the cases that we are handling at different jurisdictions, we are making the argument that the patent company, the patent non-practicing entity, essentially they are not, they file a case in bad faith just to get money out of my client based on the evidence that we have so far. And we do see articles, by well-known professors, and some courts are starting to think about the issue. I think I hope we can see legislation or court decisions soon.
Okay, but so far it is so, and that makes it quite attractive to act there. I mean, you have successful. We have there's very successful big companies. They are the global market successful, and so they are a natural victim for trolls.
Yeah.
Okay. And what would you say? Can you give any, let's say, recommendations for the defense against such trollish activities?
Yeah. Well, I can see from my experience, the case that we worked on, that we had success for the past 2 years. It doesn't look like the trolls are willing to spend a lot of money on attorney fees. So, I mean, at least as far as the case I was involved, their attorney was badly prepared. They did not turn in any claim chart before trial. And during the trial, they did not even identify our accused function. And then during the trial, they provided very weak claim chart. And we came back with a very strong defense. So essentially, first of all, we filed IPR, we filed patent validation before the China Trademark Office, and then we retained expert. We prepared expert report, appraisal report on non-infringement. So during the trial, we presented claim chart. We have expert testimony as well as expert report to support our argument of defense. So, I mean, in the trial, it's very obvious that is sliding, is very one-sided. And then after the trial, after the trial for the first case, the other side, they call the court, they file for withdrawal of the matter because during the trial, they did so bad, it's obvious they're gonna lose. So the court asked for us to see if we will agree to that. We said no. Obviously we are in bad faith. We will not agree to the withdrawal. So the court eventually issued a decision of non-infringement. And then this is the first case. And then before the trial of the second case, we submitted our like close to 1,000 pages of evidence of non-infringement. We have expert report, like appraisal report, claim chart. After receiving our evidence of non-infringement, 1 day before trial, they withdrew 3 other cases.
Okay, so what you're saying is, in other words, make your homework. But of course,
fight as fiercely as possible.
Okay. So it makes sense, so to speak, to make the homework. It makes sense to fight on the evidence base and so on. So on the other hand, this is quite costly. So that means is there any support in China, like an insurance or something like that, to help to finance litigation, or also to defense against against infringement? Is there any support there?
Litigation finance, I haven't seen that too much, because the company that I work with are usually practice entity, and they are, they can afford to pay the, they're willing to pay the fees.
Of course.
The China litigation cost is low. That's another reason why I think patent practice non-practicing entity is filing case aggressive here. It's much lower than in a U.S. case. It's probably like 2 months, 3 months of U.S.
That makes it even more attractive, right?
Yes, that definitely makes it more attractive. Yes.
Okay, and you have. In the meantime, you have very well educated, experienced lawyers. You have judges, which when I am right informed, you have the most infringement cases now on the globe in China. So you create a high level of experience there, and so it's an attractive market, so to speak.
Yeah. I actually just looked at the number this morning. There were 500,000 IP infringement cases. 500,000. Let me get the number. 500,000 IP infringement cases filed.
So when you have a source for that, I would appreciate that very much. When later to our talk, when you could put it on our discussion on the feed. To our interview, because that's very impressive, I guess.
500,000 cases in 2020.
Okay.
Yeah.
That is another answer. That's a question for another answer, which I received here in the chat. So whether infringement or whether this trollish behavior is as common, as widespread as in the US, and I would say simply yes when I hear that figures.
In addition, there's one more thing that makes China more attractive, especially before the local patent office. So the patent non-practicing entity, the first 4 cases we did 2 years ago, and the last year was before local patent office, local IP office. So the China Patent Office, they have the rule where the local patent office has jurisdiction on patent infringement, and they are required to complete a case from filing to decision 3 months. So essentially, if patent troll they file a case before local patent office, they can expect to have a decision if they can win the case within 3 months. But in our case, we filed for extension. We requested an extension because we have a testing agency. We also hired appraisal agency expert to do the appraisal report based on the technology is pretty complicated. So the court agrees to our extension. That's
okay. But 3 months is very short, isn't it?
Very, very short. Yes. So
you have to be very well prepared for that.
Very well. You have to find somebody who's really experienced before the court as well as before the local patent office, local IP office to do the.
Yeah, absolutely. So don't hire rookies is the recommendation, right?
Come to me.
Okay. So that brings me to the next question. You came up with the claim chart argumentation, and obviously, typically, we need some proof for infringement, and that's not just in China. That's typically not trivial. to get, let's say, parts, infringing objects, samples, parts, whatever, to have them prove that this infringement happened. Have you any recommendations and experience about that tricky issue of getting the proof for infringements?
Yes. Well, in China, it's a little different from Western practice where we do not have discovery. So essentially, before a case starts, plaintiff has the burden to collect all the infringing evidence. And if it is a commercially available product, we can simply buy it from the market, which can be pretty simple. But when it comes to like a business B2B product or a product which is like not a final product, it poses some challenges for attorneys to be able to collect evidence. And then if, for example, one of the cases that we handled, we had a success before the Supreme Court pretty recently, we had an infringer that is, they did a municipality waste disposal tank. It's like huge. And then my client, it's a European organic waste disposal company, which has amazing technology. It's a world-leading company. And then they start doing project in China, and then they got a phone call from their client saying that, you know what, are you doing it with somebody already? You have an authorized dealer in China? The client was concerned and did some investigation and realized that some company who wants to do some cooperation with my client, who got some information, claim to have to use the technology, and they have won many bids. They are doing like 5 different projects in China, which involves millions of dollars. Many millions of dollars. And then when we were retained, it's a chemical process patent where it's hard for us to get evidence on the infringement. So what we did is we sent investigator, we sent our attorney, we walk around, we drove around the facility. We saw there's a very prominent feature in the patent where if there's a chute on the side, that's for the processed waste to go up to the top and then go down for it to be fermented. So we saw the prominent feature, and then we use expert testimony to support our, a preliminary report on infringement to support our evidence to file the case. And during the case, we managed to persuade the court, for the judge himself, to go on the on-site inspection with us, where our engineers, our patent attorney, essentially pinpoint to the location where the judge, witnessed the testing of the temperature, on the top and at the bottom of the tank.
And the judge did that?
Yeah, the judge did that. And then we also had a mini hearing right after the on-site inspection. It's pretty amazing. The judge is so open. We are very surprised.
That's a James Bond story, isn't it?
Yeah. Yes. Well, we have a lot of James Bond story in our cases.
That means really that the judge wants to learn here whether it is or not, and really is keen on understanding the potential infringement, and the patent owner is a European company. That's really something. So whenever you want to write something about that, I would be happy to publish that, because our European audience, I would say, are very astonished about that. Because here, typically, we hear stories like not just difficult to enforce, so that when you are a foreigner, they don't want that you enforce, and so on. And that's a clear signal that, first of all, the judge has the job to find out whether there is something or not. And when there's no other way getting that impression, so even goes out of the courtroom and on site, that's pretty amazing.
Yeah, we're very surprised at the openness. Oh, the judge is super open to our. We've been on phone calls. The judge calls many times to understand the technology when in the process writing a decision. So I think the judge they really want to make sure that they understand the technology and then they write the decision in a way that will hold it. And then in the case there's also, in addition to the three judge panel, there's also a technical advisor, who is the counselor essentially to the court, to the judges. And in addition to the on-site inspection, we also managed to persuade the court to subpoena like a bidding document by the infringing company. So essentially, in China, there's a law requirement that when you bid for public or government project, you would have to submit. There's a bidding war, so essentially, and then they have to submit certain document. So we managed to subpoena, for the court to allow us to subpoena the documents where it shows clearly that it has the parameters. I mean, that has the temperature. It's the same with our patent. So we managed to. The court essentially gave us. We won the case, so patent infringement. And then, $1 million worth of damage. The company, so the infringer is enjoined from doing future project in China, and because it's a municipality project, it's environmentally friendly related. So there's a public interest concern. So the facility is allowed to continue operating, but the infringer is enjoined from further infringement. And so the infringer appealed to the Supreme Court of China, IP Tribunal. The court affirmed our decision. So we had a total success for the client.
Wow. So is there, are you also active in pharmaceutical and other IP like copyrights or know-how?
Yeah. We do a lot of, there's an increase the number of trade secret litigations in China. We do, pharmaceutical area. I recently have a trade secret case where it's two local big Chinese pharmaceutical company. And 2 months ago, we had a success representing the right owner in the trade secret case to enforce a criminal trade secret case against the infringer. 2.5-year imprisonment plus $650,000 worth of fine. So that's we're still waiting to see whether the other side is going to appeal. But it's a pretty prominent case. It's a trade secret case. Our previous experience before the court for trade secret cases is that they're far more complicated than patent cases, and courts usually our experience in 2014, we had a case, trade secrets plus trademark infringement. The court essentially said, what, we're going to focus on the trademark case, and then we had an infringement and we won the case. And then the court said, a trade secret, they just ignore the claims. But recently we see more and more trade secret cases. In our case, we are, we engage. We're so engaged with the prosecutor's office. We supplemented their evidence, because when we were involved, we got involved in the matter. It's before trial, literally before the trial, and the client their case was in such a bad shape because the element of trade secret they submitted, and the defendant they don't practice because they changed different parameters. They don't practice, and then there's one the defendant not practicing at all, and then the document the public for trade secret you have to do a search to see whether it's public knowledge, right? So the public knowledge report they submitted, it's they essentially did a patent infringement analysis, so which is in a totally different direction as opposed to trade secret. And then the other side, they are pushing very aggressive in the case where they retained prominent trade secret and criminal professor to be the expert, and they submitted an expert report to challenge the client's submitted report on infringement. And also the professor, he published articles even before the prosecutors, the general prosecutor's office, they have a journal. He published an article on that and saying that in such and such case, such and such, this is like bullshit. So they give us a lot of pressure. So we got retained. The client case was in very, very bad shape. And then we also the other side, we pressed the court for an open public trial because they said, you know what, you said we misappropriate your trade secret is public already. So, why not have a public trial? So the first argument we made to the court is that, we did a non-publicly known trade secret the points. We did some research saying that it's obviously not known. The infringer who used to cooperate with us who was the manufacturer for the client, limited disclosure to them for cooperation purposes is not publicly known. And we managed to persuade the court to have a closed trial. So that's point one. And then we also supplemented the evidence to support our trade secret, right? For trade secret, you would have to have your document to support what is your trade secret, what did you come up with, how is the parameters, right? So we managed to sift through like millions of the client's emails, document to look for such document, and we managed to. There are, before we joined the case, the previous lawyer, they submitted 84 drawings which did not correspond to the trade secret at all. So it doesn't show they have the trade secret. It's unrelated. I don't know how they come up with the support, but we sift through so many documents. We managed to find close to 100 drawings where it clearly shows that we have the trade secret. This is what our trade secret is. And when we identify,
that's the most tricky thing, right? So
very
showing what is it at all at the end.
Yeah. That is the most tricky thing. And also we supplemented the non-public known search report. We also retained well-known criminal professors, and as well as one of the former head of the China Patent Office, the pharmaceutical tribunal. So he was the head of the tribunal before retired, but he worked for the patent office. So he's pretty authoritative too. So we managed to have all this, all the factor combined. And then we had the court is a very complicated case. So the court have 7 people, 7 judges on the tribunal. And then they have 2 independent technical advisor to the
court. But that was not such a 3 months decision, right?
No. This is a court decision. So before we got involved, the case has been going on because the police investigation, prosecutors, prepare the case, has been going on for a long time. And then after we joined the case, we managed to extend the case for another, I think 8 months before we get all the evidence, get it submitted, and then work with the prosecutor to update our evidence. And then we had a success for the client, which the client is super happy. The judge even called. The judge later told us, after sending out the decision, the judge said, "I call your client." And then this is what I said. So without this attorney, you won't. This case will be a very different story, a different decision.
Yeah, of course. I mean, that's why I have an attorney, right?
Yeah.
I mean, especially an attorney who knows really the local situation, who understands how to present the evidence, how to get that, and here especially this difficult issue. What exactly can we call here the trade secret? Yes. How can we show that we tried to keep it secret? And that there was a theft anyhow. I mean, that's the next thing. So how happened the transfer? I have right now a story before the Chamber of Commerce in Paris, and one company says that there is know-how stolen, and The other company says, no, it is so trivial, it is not necessary to steal anything. And now we are in the middle of the discussion what exactly might be stolen. Yeah,
Mhm.
and that is so tricky to prove. I mean, I'm happy I'm not a lawyer and I'm not an attorney. I'm just the guy for the figures as evaluator. But again, the legal question and the technical question. So first, was there a theft? And second, what exactly should it be that it is necessary for producing the product? I mean, that's really tricky. And also a whole flock of lawyers are working on that case.
Yeah. In this regard, we also see promising guidelines from local courts. See, for example, in Zhejiang province, Zhejiang High Court, they issue a guideline. Essentially, they have their local rules saying that if you're doing case before us, you would have, as the plaintiff, as the trade secret owner, you would have to identify. So early identification of your trade secret, that's a requirement by the court.
Absolutely. That makes sense. Yeah.
Which helps a lot.
Yeah. Let's switch a little bit. Let's shift the technology field. So we have also pretty much heard about internet case in China, and really some guys call it a war. At least it's a battlefield, but I would say it could be called a war. And what would you say? What can we learn from that case and from that environment, which is now a little bit? I know that you are also specialized in SEP infringement and enforcement. What is also a very special world, in addition to friend discussions. So what would you say from a Chinese and from an IP perspective? What are the takeaways from this case?
On the internet area, we did like over 20 cases within the past 3 years, representing a prominent search engine in China. So essentially, we represent the company, and then the competitor, Baidu, our client is Sogou. So they filed 29 patent infringement cases against each other. The technology they are fighting against each other is the Chinese character entry method. So there are AI involved. So when how do you enter Chinese language into your computer?
Got you.
Like voice communication, like you have to, pronunciation based. So there are different ways to do it. And then there's also like if you enter 2 of the words, you're gonna get a guess. Have a guess as to how they guess what you're gonna say next, and then it appeared in the. So that's these are the primary technology they're working on, and they filed 29 cases against each other, and then there are corresponding patent IPR invalidation cases filed before the patent office, and then there are appeals from the infringement case, and then there are appeals from the IPR, and then second instance appeal of the IPR. And then after the first round of IPR, in China, there's no limitation as to how many times you can file IPR against one patent. So there are second round of IPR, there's third round of IPR. So in this matter, we did over 20 cases. 2 of them were named Case of the Year. So 2019, China Business Journal named one of our case in the matter, in the series of matter, Case of the Year. And then 2020, it named another case in the series, Case of the Year in China. And then one of the cases also selected by the Supreme Court of China as exemplary cases of 2020. So essentially, the core issue in the matter is, the good legal doctrine that we have, I think, with from the case is estoppel issue, because before that, the court has never done a trial on so many internet software related cases. So the industry, the entire industry is looking it has set very important precedent. And then in China, the two companies, the patent infringement case against each other between the two companies is called the Internet of Wars, the wars of the internet. Sorry. So the war on the internet. So I think there's an important doctrine in the case where I can is estoppel, because in one of the case we managed to find a prosecution history estoppel where the opposing side, the patent owner, they essentially said, if you have this, if you show this is not our product. So we found this, their limitation, and then we did many experiments. We found one of many. We found like 5 to 10 different ways to show it where it's exactly where the patent owner excluded in the file history. So we showed it to the court, and then this is clearly non-infringement. And then the appeal to the Supreme Court, which affirmed our success. So the estoppel get very complicated in the matter because it's not only file history estoppel, it's the court, right? The plaintiff, the defendant, the patent trial examination board, the first instance court, the second instance court. So whichever party, 3 parties in different, the court, patent office, appeal, second instance, whatever they say, we take advantage of all their, we sift through all their argument to find estoppel, and then manage to use it, in favor of our client, to our client's favor. So I think this estoppel is one of the important factor or element that I think is good of the case.
Can we learn something about the enforceability of software-oriented patents out of that case?
Yes. Yes. So as I said, 29 patent cases were filed. So 29 patents. So in China, you're only allowed to file one case involving one patent. So 29 patents were filed, and then we did some analysis of the patent. So 1/3 of the patent was entirely knocked out. 1/3 was partially maintained validity. The other was 100% maintained. So it's but in the decision currently, so far, the decision we have so far is, the patent was either knocked out, or if the patent remains valid, there's no infringement. So far, the two companies, they are doing, yeah. So software patent is hard to get in China, and then we do see some issues with respect to their validity when it comes to.
And when I got it right, you just checked whether the functionality is implemented by testing the software, whether it is doing what is described in the patent or not, right?
Well, so essentially, this is, so we couldn't see what the other side is doing, but we purchased a cell phone embodied with the software. So what we can do is we can show to the court, this is what it shows, because when you enter certain words, there are like different words they can sort of have the link where you can click on, and then it shows the character or the function that the other side claimed that they don't have. This is the way how we do it. And then in software cases where, in this case, there's another. Go ahead.
Yeah, I mean, so the idea here is, so when you from the other way, when I say I want to have an enforceable software patent, I mean, that is something which I'm discussing here in that format and in other formats again and again.
Yeah.
And companies ask me, so how can we get something which is enforceable? And my general recommendation is try to patent something which the customers can see. because when that means you can show that there is a strong hint of an infringement. So when you patent something which is deep down in your software, so it is more or less impossible to get an infringement proof for that. And this is exactly what you confirm now, that at the end you buy a cell phone, you click, you use the keyboard showing that happens, and then you can show to the judge that there might be an infringement of that.
Well, this case is a little different. Because of the way how the words that are, the computer sort of did a AI relationship, and then it came up with a word. So the word that show or doesn't show distinguish whether it's the patent or not. So it actually show on the surface, not necessarily all embedded within the software. But in other cases where we do not have access to an appearance on the software on the cell phone, we managed to persuade the judge to do like a disclosure of source code. So this is another, I think, a pretty interesting factor of the case, is because the judge allowed us to do limited discovery. So source code is part of it, and then the companies are very concerned about disclosing their trade secret, their source code to the other party. But the court ordered only the attorneys to view the opposing side's source code only in the courtroom. So before the hearing, we had many opportunities to view the opposing side's source code without the client, and then we can also go with the expert. So with that, I think the court preserve maintain the confidentiality of the trade secret and ease the parties' concern. I think.
Okay. Yeah. But that's quite hard, right? So it's much easier when we are on a level where we have a use case or any functionality which can be seen or excluded or whatever. Yeah.
Yeah, and sometimes in one of the cases we also retain expert. So we retain an expert where the expert essentially demonstrate or explain to the court, this is what happened beneath the cell phone. As as a professor, as a industry expert, I know for sure this is what happened. So because we don't have any other way, and then the burden shift to the other side for them to either produce the software or the source code, or to show to the court how they did it.
And can you see, to come back to our first topic, can you see that this trialish activity, that they prefer certain industries? So what we see, for example, in Europe is that we have many cases here on standard essential patents, so telecommunication, also software standards. Is that similar in China, that there's a certain preference on the industries?
Yeah, I mean, if you're talking about the patent non-practicing entity, I see it's in particular, I think, focused on the electronic area, where multinational company, they have a lot of investment or interest in China. And then if you're talking about essential standard patent, yes, it's particularly focused on telecommunication area. We did a case representing a major company fighting against, it's a quasi patent non-practicing entity. So it's a Wi-Fi equivalent, WiPi. The technology is called WiPi. In China, and then it's before the Beijing IP Court. Is a pretty prominent case of the year. It's 2016 case of the year by the Beijing IP Court, and its technology is wireless communication area. And then the plaintiff actually filed case against many, including Apple. I mean, if I talk more, you know which case I'm talking about. So against Apple and many other major wireless players in China devices.
Yeah. So Ping, I could talk with you for hours more because it is fascinating, and what we all see is that you like your job, and and that it is really important to have this kind of local experience, but also, as you said, you're reading source code, so it should be an expert in addition, and understanding the procedures and the technology. So Ping, thank you very much. I definitely will come back to you to talk another 45 minutes on that topic because it's so fascinating. And thank you to you in the audience. Thank you for your questions. And we have another SAPI IP Business Talk next week. And then we go into our well-deserved summer break. So see you next week. And Ping, thank you very much and bye-bye.
Thank you, Alex. Thank you, the audience. Enjoy the